been one of those things.
I think number 3 is something that we can handle today, Your Honor.
Sure. Turner and Turner 19-300-66908. We're reviewing payment status.
And so I don't see Mr. Turner, and I spoke with my client the other day, and she said support hadn't been paid, but sometimes she gets it last minute. I'm not sure if Your Honor. So in the past, we've set this over with me to give him notice that he has to be here yet again. He's supposed to be here today, but he's not. So I'm just, it's whatever you want, Honor wants to do. If we want to issue a bench warrant because he's not here, or set it over, I'll give him notice and tell him to be here. And it's a review. And the only information I have at this point is that no information yet. None confirmed that he's paid support for this month.
Well, is he usually late as well? Sometimes we end up recalling.
Sometimes, yes.
Okay.
He's had a pattern of that.
All right. I'm just going to give a call out. There's a phone number here. So is there Daniel Turner present? I'm inclined, given our situation, to set it over, Mr. Anagnostou, and then if we don't have him at the next hearing, I'd consider a warrant at that point, especially if there's still been no payment. But to give him notice, is 1 week sufficient, or would you prefer 2?
I would it's going to have to be 2. I'm going to be out of state next week.
Okay, so the 30th at 1 p.m.
Very good, and I will send him a notice that he has to be here.
That's ready, Judge. That's just on for a review of GAL compliance, I believe, and I know that both parties have spoken to Ms. Height, who's working on her investigation. I don't believe I've been provided with any written findings or recommendation as of yet. So I think it probably makes the most amount of sense here for Ms. Height, and then set this out sometime so that we can have the report. Summer is coming up here shortly. Parties transition to, I believe, a week on, week off plan once the summer starts. I think we just need some kind of review as to where the child's going to be living and going to school come the start of the school year in late August or early September this year. So I don't think we have necessarily a huge time crunch, but we would like some resolution well ahead of school starting.
All right, Ms. Holder, any additional information from you?
No, Mr. Zandy summed that up very well.
All right, Ms. Height, how are things going on your end?
Yes, Your Honor. This was set for compliance review, and I have had contact with the parties. Both have paid their fees. I did note that there was an interim review set for May 23rd, which seems unnecessary at this point. I agree that the key issues need to be resolved before the end of summer, and it's currently set for a final report that's due to be reviewed the 1st of August. And I believe that that is where we should leave it today. I don't think an interim review next week, there'd be much point in coming back for that.
That seems fair. Do parties agree with that?
Yeah, that makes sense.
All right.
Yes, Your Honor.
And August 1st works for all parties?
Yes.
Yes, Your Honor.
All right. Well, then we'll keep this matter set for August 1st, and I'll strike the review. Interim
in
review.
this matter, I'm actually going to, I think it'd be hard for you to deal with it without Odyssey. We do have Ms. Gibson present. B, I'm going to ask that we set this matter over to the 30th. So discovery is a big issue in this case. We actually just this morning received documents we had subpoenaed from AT&T and are now being able to go through those and compare those to what we received from Ms. Gibson. And that, I think, will illuminate a lot of the questions. But that'll take us a little bit of time. So I'm asking to set to the 30th. That gives us time to review that and then provide sort of a summary and some of those documents to Your Honor.
Right. And Ms. Gibson, any questions or concerns about that?
Is that just in regards to the discovery, not in terms of the GAL report, or is this for both items?
I would, so we're actually on for review for a number of things, but again, because if you don't have access to Odyssey, I think that's very challenging to be able to suss that out. So we're on regarding reviewing the home, the guardian ad litem report, and discovery issues. So there's a number of sort of pending items. I would just ask we move those all to the 30th.
So that is correct. I'm seeing, Ms. Gibson, that it's review of GAL, review of attorney's fees, motion to compel, and order to compel. So there's several different things that we were going to touch on today, and that would all be set over to the 30th. So any concerns with that?
No, if Your Honor needs access to Odyssey in order for us to accurately and effectively be able to do those things, then it doesn't really seem like we have an option but to set it over.
And again, my apologies for that. So we just got an email that the fiber optic cable that was cut has refractured. So they're not even giving an estimate on when that matter will be resolved at this point. So let's set it to the 30th. I appreciate your patience with us, Ms. Gibson. And thank you, Ms. Baldwin. So we'll set the Gibson matter over 2 weeks to May.
And that
30th
matter's
at 1 p.m.
ready-ish. I was going to defer to the court if you wanted to set this matter over a week. It is on for a motion for contempt. I will just note for the court that I did receive a response from Mr. Fuentes last Tuesday. There wasn't a whole lot that I think needed to be responded to, but I could provide a response, a written response, or we can set it over a week so that Your Honor has access to Odyssey. I guess I would defer to Your Honor how you'd like to proceed.
So this was some of these I may have some memory of, and we can try to move forward. But this was it's a contempt, if I'm remembering correctly, and it has to do with YMCA.
Correct.
Okay, and I believe I don't remember all of Mr. Fuentes' reply, but I think he indicated that he did make a payment to your client for those or he stated he did that as part of his reply.
Correct.
That's the extent of my memory on this case. So if you want to move forward, I'm comfortable, but I may ask you to just kind of refresh my recollection on certain things.
That's fine. I have no issue with that. I can proceed. So as the court is aware, I do represent the petitioner moving party, namely Candace Fuentes, in this matter. As Your Honor provided a brief recap, this is largely as it relates to the YMCA. The child, Sailor, has been enrolled in the YMCA after school program prior to the party's dissolution being finalized. And only recently has it become an issue. As contained in my client's motion, Mr. Fuentes had essentially stopped paying for the YMCA, indicating that it wasn't daycare expenses outlined in the child support order. I will acknowledge my client did indicate that he did make a payment last Tuesday, just prior to filing his responsive declaration. However, as contained in my motion, these expenses are ongoing. It's $125 per month. Granted, this is a minimal issue in the grand scheme of things. However, it's an issue that has been ongoing, and it took my client bringing this motion for contempt for it to be paid. So we are asking the court to find contempt. Given the fact that he has already made that payment, the past due child expenses that I have contained in my order can be stricken because those have now been paid. But we still are asking for an award of attorney's fees, given the fact that it did take this motion being brought in order to get that payment. Additionally, we are asking for some language to be included in the order, which I believe that my proposed order has in there, that essentially says that the reimbursement needs to be paid within 15 days of being given the receipt. As my client indicated, without any sort of timeline as for repayment, we're running into issues of threatening contempt in order to get payments, going forward with motions of contempt in order to get repayment. And my client would just prefer to avoid having to continuously come back to court for expenses that are required to be reimbursed by Mr. Fuentes. Those are the basis for our motion for contempt today. Obviously, if Your Honor has any further questions, I'd be more than happy to help.
Thank you very much. Good afternoon, Mr. Fuentes.
Good afternoon, Your Honor.
I remember some of your response, not all of it. So any information you want to provide, I would appreciate.
So I've currently put my own debit, my card on the YMCA to pay my portion of the YMCA for my son. But prior, I never received any receipts for any of the payments that I've made to Candace. I've never received a single receipt for anything. And
can I ask a quick question? Do you mean
Yes,
receipt like, here's what I want you to pay, here's a receipt of what I paid and I want your half, or like a receipt of, Josh, I received your payment, that kind of a receipt?
The receipt for the payment that I made, because I transferred
Okay.
money to her account and she hasn't given me any, I have no proof that I've paid her just through transactions, and it was for my
Okay.
tax purposes. And
Gotcha.
she's refused multiple times.
All right. Sorry.
So-
I appreciate you clarifying that. Go ahead.
So I will continue to pay for the YMCA. I have no problem with that. I just wanted receipts, and she wasn't compliant with that. So for me to be in contempt of court for it, for her not providing me with the receipts, it's a split thing for me. I've never missed a single payment at all for her. So I'm trying to get, so I can pay all my half of my portions without having to transfer money to her or have to pay her back, because it's just been an issue, and here we are.
Okay. Anything else?
I just hope you don't buy me in contempt of court, and we'll just want it resolved, basically.
And the additional proposal that she's offering up about having a 15-day turnaround, any concern with that? change?
No, I have no problem paying the bill, or paying the bills within 15 days. That's not a problem.
All right. Thank you, Mr. Fuentes.
Thank you, Your Honor.
Ms. Bliss?
And just briefly, Your Honor, if Your Honor refers, well, obviously you can't refer back to my motion, so let me rephrase that. As attached with my motion were email correspondence between Mr. Fuentes and my client saying, I am not paying the YMCA bill, so stop sending them to me. It's a clear and intentional violation of the order, which requires him to pay daycare expenses, which now all parties have acknowledged that YMCA is after school daycare expenses. I acknowledge the fact that he is paid now. I'm a little confused as to the wanting receipts after making payments to my client, but I will discuss that with her and attempt to resolve that issue as well. But there was no discussion as to my client not providing him the invoices for the expenses paid or making requests as required for reimbursement under the child support order. This is a willful and intentional violation of the court order, and unfortunately, it took us bringing a motion for contempt for it to be resolved.
I have no idea.
So I do remember, and I do recall seeing some attachments to the motion for contempt, the show cause order, that the text messages and the responses, and just the, I'm not going to pay that. It's not daycare. So here, I am going to find that it is a contempt. I'm going to impose the $100 civil penalty. I'm going to strike out the past two expenses. Those appear to have been taken care of. I'm going to impose $250.
Bouchard,
Okay, you need to remain muted, please, until your case is called. $250 in attorney's fees, so a total of $350. I'm making the changes on both sections there. The reimbursement within 15 days seems appropriate, and I'm going to add in language, because I think it sounds to me like the parties want to work together, and now that this is clarified, I don't think Mr. Fuentes is going to have any problem doing this. I understand his request. Mr. Fuentes, would I guess are the two of you communicating via phone or text or email? Are you or through an app?
We email and briefly text.
Okay. Do you want something other than a text that payments received?
I would like proof of the payments that I've made, so I have those for my records. I asked her for receipts for them, and she's failed to do so. I don't know.
So would that be a snapshot of her bank account? I mean, that's showing that the transfer went through. Why wouldn't a transfer from your account to her account on your side be enough?
So my transfers don't say what it's for. It's just a little note through Red Canoe Bank that just says what the payment is for. It just says like medication. You only got a certain amount of letters you can type in there. So there's no, it just says payment or, for this. It doesn't show any proof of it.
Ms. Bliss, do you have any ideas? I get what he's asking. I mean, he doesn't want to, have her say, hey, I never received that, and then him not have any way of
absent maybe in whatever text line that you can do for the transfer, meds or YMCA or what have you, if he did that, and then like Your Honor suggested, maybe just an email saying, I have received your X amount of payment for this
and I have it and everything.
Sorry.
I don't know if that would be sufficient. I think that's absent her going out and physically getting a receipt book, which I think is excessive. I don't know how else to remedy that situation. But I think if my recollection from what my client has provided, I think that she already does do that. But if she doesn't, then I think that maybe adding that to the order might release some tensions and conflict moving forward. You wanted to start paying her via like Venmo, where you can say this is what it's for, but again, that's using an alternative method that the parties have already been using. So those are just some suggestions that I'm coming up with as we go along.
Well, I mean, yeah, and I don't know. I am going to add to the order, Mr. Fuentes, that the petitioner provide confirmation of payment to you. If you can mutually agree that maybe you do switch to Venmo for this, because then there's going to be a transaction record going both ways, and then both of you have it all right there in front of you. I'm not going to dictate what you choose, but hopefully if you can figure something out that maybe works better for both of you. But I am going to include under here that the petitioner shall provide confirmation of all payments to the respondent. So that way, hopefully this does not cause any further issues for either of you. 08.
So I want to resolve this today, but I also know I'm going to argue about things that were filed previously that now you don't have access to. So that would be my concern. Based on sort of what we're here for today, arguably my client is the only one prejudiced by maintaining the current order. But I want to have a full and fair hearing. And so with that, I'd probably ask the court set us to the 30th. I'm not available next week. So I'd ask that we just move it to the 30th.
Ms. McLean?
I'm just pulling up my calendar. Bear with me just one moment, please. I could do the 30th.
Very good. Thank you.
And do you need Ms. Height to be here? And Ms. Height, are you
Yes.
available on the 30th?
Yes, Your Honor, I am.
All right. Well, I have no idea how big that docket's going to be, and it's my birthday, but my husband will be out of town, so it'll be fine. The clerk, I don't even think can check to see how many are on that date, but so just everybody's continued patience is always
Your Honor,
appreciated. So we'll set Kaufman and
I
Kaufman
thought
over
somebody
to
on here
30th.
iPhone that I thought maybe was Ms. Barbo. She's called here several times. I know that my staff has been emailing her the contact information for today's Zoom hearing, and I had received, I don't know if you have anybody in your waiting room. I had received a phone call from Ms. Barbo's sister yesterday and also provided her with the information on how to log on for Zoom today.
I don't have anyone in my waiting room. There still is an iPhone here.
I don't know.
Rebecca Barbo, if you're present, if you could unmute. And while I ask for Miss Barbo to unmute, Miss Gilmore, Miss Houston is logged out and logged back in. She's going to try and still not working, and she's going to try on her phone just to keep you apprised of the chat.
So apparently I just asked my staff if we'd heard back from them. And she said that she thought that they were on, they just didn't know how to identify themselves. So I'm wondering, I don't know, do you have the ability to?
I can ask them to unmute.
Oh,
Hello, is this Rebecca Barbo?
Yeah, it is.
okay.
All right. I have some, I think, relatively decent memory about what we're here for, but I think we should be able to proceed. So I'll go ahead and turn it over to Ms. McLean.
So, Your Honor, this matter started with a decree of dissolution being filed back on December 29th of 22. And in that decree, my client was awarded the real property, and Ms. Barbo was ordered to sign the quitclaim deed and Rita's within 30 days of the decree being entered. We had attached to my client's motion, or to his declaration, actually, verification of the correspondence that I had sent to Ms. Barbo, as well as verification that we had provided her with conformed copies of the final orders. Unfortunately, she did not cooperate in signing the quitclaim deed and Rita's. And at this point, we're simply asking the court to sign my order that allows for Commissioner David Nelson to be appointed in order to sign those, both the quitclaim deed and the Rita's in her absence. I will tell the court that since filing this motion, apparently the Rita's with the county, the real estate excise tax affidavits with the county have been updated. And I just found out by circumstance because one of my Rita's in a recent case was rejected. So I had hand delivered up to your office today the updated Rita's for this case. The other issue is that there was a protection order that was entered. Unfortunately, Ms. Barbo had violated that protection order by coming to my client's residence, at which time my client agreed to store her vehicle and whatever personal property she had in her vehicle so that she wouldn't incur impound or fees affiliated with towing the rig. So he currently has in his possession her vehicle, her personal possessions, as well as the agreed upon community property that she was supposed to receive from the decree of dissolution. We've attempted, my clients tried to communicate with her family in order to arrange for that to be provided back to her. Obviously, I'm sure that they're concerned about the fact of the protection order, but the protection order provides specifically in that for my client to be able to communicate with the family in order to get items back to her. So we're simply asking that the court sign my order. Sign my order that simply provides that my client can arrange to deliver her vehicle and her personal property items to her home in Ridgefield. And then the only other item that we need to receive from her is the blue alarm remote for the real property. And we're asking that she be ordered to deliver that to my office by this Friday. And we close on Fridays at 3 p.m.
All right. And the clerk provided me the Rita.
Yes,
This would go to Commissioner Nelson, correct?
that along, so you should also have an order appointing commissioner to sign deeds and other relief. And behind that should be the quick claim, the commissioner's deed pursuant to RCW 628010.
Mhm.
So I would need you to sign, if you approve it, my order. You'd also need to sign on the court approval line on page 2 of the commissioner's deed. And then the commissioner's deed and the Ritas would go to Commissioner Nelson to sign.
Okay.
And then I would need the originals to be able to file with the auditor's office.
Okay.
And I can arrange for my staff to pick those up.
Okay. Thank you very much.
And I guess let me just say one other thing. The deed needs to be notarized. I'm assuming that the clerk's office has a notary, but if they prefer to have I or one of my staff who are notaries to arrange to come up to notarize that for Commissioner Nelson, we can do that as well.
All right. So Miss Barbo, any comments, questions, or concerns?
Yeah, couple of things. One, I don't have current transportation, so I don't know if I can deliver that remote this Friday. I'm not sure because I don't have my car. My vehicle is up at the house. I need to have ability or options or connection with my ex-husband so I can get my vehicle, and I need connection with whomever so that I can have an access to go ahead and get that so I can try to go back to work and get possessions. I have not been in the house. I was given 15 minutes when I was served a protection order during the time that my husband filed for divorce, and give me the divorce, talked about the quitclaim deed. I was going through some very stressful stuff, so I wasn't really understanding of the quitclaim deed and all that information. And again, I don't have my vehicle, and I was only given 15 minutes to get out of my house the day I was served that protection order. So I don't have hardly anything on me. I didn't have any clothes. I didn't have any warning or nothing. And I haven't had my car the whole time. I had to go live with relatives, and it's been a mess. Okay.
Okay, but it sounds like you took your car and left it with your ex-husband. Is that correct?
No, I left it because I tried to enter the residence, and I ended up going to jail. So because
she was arrested for violating the protection order.
So I went to jail. My car was my car at my residence, even though my husband had filed for divorce. I had no idea he was even filing a protection order. Nothing was said, and we were getting along just fine. And there was some other lady he was seeing, and all of a sudden I had a protection order. I was asleep on the couch. I woke up, they came to my door. They said, you have 15 minutes to get out of the house. I had no notice of any of that except for some quitclaim deed. And so they come to my door and they're like, you have 15 minutes to get out of your house. No warning, no nothing. I've lived in the house. I've been married for 16 years. That's exactly what I've dealt with. And I have no vehicle. I have none of my clothes. I have none of my shit. I couldn't get in the house, and they took me to jail.
Watch your language. You're in court. All right. Well, we're in a situation where it sounds like there's been efforts made to try to get a hold of you through your family to get your stuff back to you. They're continuing to want to do that and get your car to you. And they're looking at working either Mr. Barbo himself or through some other party to deliver your vehicle and all your personal property to an address in Ridgefield. Is that where?
One more time? Yeah, I'm staying at it. I can give you the address, and that's fine if it can be delivered.
That's what they're asking to do.
Okay.
And then as far as the blue alarm remote, I don't know if that's something you can put in the mail to Ms. McLean's office.
I can put it to the office there with Noelle.
Yeah, you need to send it to the PO box.
Okay, that's fine.
PO box 757. So just so the court's aware, the protection order indicates that my client would communicate with her sisters, Mariella Yancey and Aletha Holdorf. Aletha Holdorf was the one who called me yesterday. And so if Aletha could call me back and we could see about arranging times to exchange stuff or whatever.
That'd be great. So she'll call the Noelle McLean office, and then
Sure.
we can get some stuff out of the house and my vehicle.
Sure. We'll arrange for that just so long as Ms. Barbo is not present. Ms. Barbo cannot be present at the home, but her sisters and John Thompson, I think that's one of the husbands, I think, of the sisters. All of those three people will work with as far as retrieving those items and getting those back to Ms. Barbo, and then perhaps they can just deliver the blue remote.
Okay, so I need you to back up just a little bit. So you're saying I can't enter the home and the relatives will get the items?
Yeah, there's currently a protection order, so Ms. Barbo cannot go to the residence.
Okay, so I have to tell my relatives what I need. And what about the vehicle? How does that get delivered?
We'll give that to them to take. So if you could have Aletha or Mariella call my office, then I'm happy to talk with them and see what we can arrange.
And you're Noelle McLean?
I am.
Okay. And you must be the one we talked to on the phone.
Aletha called me yesterday.
Okay. Because we talked to some of your office and I could barely hear. So I think that was you.
You didn't talk to me today. You talked to my assistants, Amanda or Trisha.
I'm sorry. I could barely hear her. So I didn't know who.
That's okay. All right. Thank you.
All right. And I've signed that order appointing Commissioner Nelson in both on page 2 and then on the second page of
the commissioner's deed. Okay. And then if either one of your judicial assistants or if the clerk's office can let me know if we need to run up and notarize at a time that's convenient for Commissioner Nelson, we'll do that.
Okay. I appreciate that.
Thank you.
I guess Ms. Cutter, if you could just note that. And we used to have a JA that was a notary. I don't know if we do anymore. So
the clerk's office does not have a notary.
Clerk's office doesn't have a notary. So
okay.
Maybe there can be an email exchange with Commissioner Nelson regarding a date and time.
Sure. Okay.
Perfect. All right.
Thank you.
Ms. Barbo, you indicated you had a last question.
Yeah, I did. And I'm sorry, I didn't know if you heard me or if I was still in queue. Is that common for a protection order to be served like that? And if somebody has 15 minutes to leave their residence and not be aware of all that, is that, I'm not even aware that, I've never heard of that before, where they tell you that and you have to be out of your home.
Well, Your Honor, I guess I would just indicate that that's not properly before the court.
It's what?
She says it's not properly before the court. So I will give you a part of an answer. A court has authority to issue a protection order, and they do have the authority to order someone to vacate a shared residence as part of that. And that initial finding can be made without notice to the other party. So, but I don't know your case. I don't have the information in front of me, but that's just sort of some generic information for you there.
Fine. I'm sorry. I've never been through anything like that. And I don't understand how they can do that, especially if you've been married for 16 years and just ask someone to leave their home like that with nothing on their back and nothing.
I wish I could give you a better answer. I'm sure that was a difficult situation to be in, but without having any other information, that's as good of an answer as I can give you at this point.
Okay. And then one other question. At this point in time, we've been over everything that we need to go over, and I'm going to just mail in that remote to that office for Noelle McLean. Is that correct? And then they'll be in touch with my sister will contact them to be distributing possessions and get a vehicle to me.
Yes. And the other alternative, it sounded like if the arrangements are made this week, your family can bring that remote in instead of you having to mail it. If it's this week. If the parties, if everybody can't coordinate this week and it's, a week or two from now, then mail it in. But if they can get it done this week, then sounds like Miss McLean's fine with them just bringing it to Houston. Is that how you say the last name?
Okay.
Or is it Hudson? Okay.
It's
Houston. All right, good luck. Okay. Thank you. Okay. Miss Gilmore.
I did receive correspondence today from my office. It looked like it was mailed in regarding a witness list. I did have some outstanding discovery, but I did get some response within that correspondence. So my hope is that I can just work with Miss Houston to get that exchange in the next couple of weeks. So I do think that we are ready to proceed. I would ask if she is comfortable, if she could provide me her email so I could have better, quicker communication if possible.
As far as I know, you had my email address. You and I have communicated through email once before, so I wasn't aware that you needed it again.
I don't have it in my records. I couldn't find it. So if you could provide it again, maybe in the chat or call my office and provide it.
Okay.
And Ms. Gilmore, I'm assuming there's already either a readiness hearing docket that this is on or a trial setting docket that this has been on?
Yes, the week prior to June 5th. So in about 2 weeks from now.
Okay. All right. So Ms. Houston, it sounds like the case is progressing to trial. If you can provide either in the chat here today or just call Ms. Gilmore's office and give her your email so she can communicate back and forth with you getting prepared for that trial, that would be appreciated.
Yes, ma'am.
All right. Thank you for being here. I got your
Thank
email.
you.
Thankfully, I did all my notes on the actual order, so we can handle this today. Your email indicated that you agreed to the changes in the child support order. Is that correct?
Just one section, Your Honor. I corrected section 22, which was one of the objections made about how our family would be used for payments. I just wanted to confirm that payments weren't going through the app. So I corrected that language, and we discussed that with Mr. Davis, and I think we had approval last night. So that was the addition we made, but there's still 2 issues before the court.
All right. So I'm gonna sign the child support worksheet. Child support order. I have section 19 and then section 22. 22 was agreed. So we still need to discuss section 19. Okay.
Correct, Your Honor.
All right. And that is the tax exemption. So go ahead, Mr. Davis.
Your Honor, did you, it sounded like you did receive my written objections or have read those?
I did. Yes. Yes.
Okay.
Thank you.
So just quickly, I don't want to repeat what you asked me to do in writing. The short of it, Your Honor, is they're requesting mother receive 2 and alternatively the other child every other year for tax exemptions. Future years may be an issue if mother finds a job and starts working at some point, but for 2023, we're at May already. There's no benefit in giving mother any sort of tax exemption. She has no taxable income. We had asked the court to impute her, and there was discussion about that, stating that she hadn't worked for some time, and there was 2 minor children. There was some discussion whether that would be fruitful or not. Employment, at least in the short term. The court did not impute her, and it gave her $5,200 in family support, which is tax-free to her. My client continues to pay the tax on that and his small remaining income of $1,500 or so, maybe a little less than that. And so that's the basis of that. She would have to earn substantial money in the last 5 months or 6 months that we have left of this year to even benefit from those tax exemptions. My client's income was calculated using the tax exemptions they have historically taken. His income would have been even lower, his net, if we knew that the child, 2 children, possibly 3 children, were not going to be included in that. And so that's the basis of our request. It doesn't benefit mother at all. She receives all that money tax-free. Father has to pay the taxes and all that. He's the only one that would benefit from that. Without those extra exemptions, his income's going to go a lot less than the $1,500 that the court's giving him now. And so that's the basis of that. The other request on there is the January 31st, current on the payments issue. That's fine. One thing I failed to put in my notes to you was I'd like to have the deficiency notice sent out by mother on January 10th. So that way he can get current by January 31st. I've had that issue before there where people say, well, you weren't current. Well, it was a $25 bill no one told about, in the beginning of January, when that could have been easily rectified. And then you have the court trying to decide if that's fair and whatnot. So no objection January 31st. I just wanted January 10th or 15th, whatever the court wants to put in their reminder of the deficiency if she's going to say that he's deficient in some manner. But the big issue with that, of course, is he's the only one that benefits from the tax exemptions and credits. He's the only one with income. He's the one paying all the taxes for her and him. We think it's justified that he receive all those for 2023. Now, if 2024 changes and she becomes, gainfully employed or whatever, that can be reserved, of course. And court, I don't have a problem with the court reserving that now if it wishes for future years. But 2023, it only makes sense to us to have father receive those exemptions.
Okay, Ms. Green. First, the currency notice by the 10th of January seems reasonable. Any concern with that?
That was why I added in section 22 that all the bills would be paid through our family wizard, because it tracks all the bills and the parties mark when they're paid and not paid. So, it's duplicative of what our family wizard offers. If she's providing him bills and vice versa, and they're marked paid, there shouldn't be any issue with knowing what is or isn't paid. So I haven't had that brought to my attention before. I don't think there's an objection, but I think it's just as easy for father to look into our family wizard and see if he's paid them all, if they're both using that app.
Okay. And then the 2023 tax exemption.
So for 2023, my client hasn't currently worked, but there's still more than 6 months left this year. So the issue is, if she does get gainfully employed, she only needs to make basically $5 if they're filing separately to have to file a tax return. It would be appropriate if she earns, I think the minimum for taxes would be $11,000 in the year, if my recollection is correct. That she would have a benefit, that the tax claims would be beneficial to her to claim the children. So I do believe that by having father basically be able to claim the children, it loses her the ability to become employed and to claim the children. Obviously, we'd encourage them both to file jointly for the tax benefits for both of them, not just for the children, but for the house and other exemptions. But if they aren't going to agree to file jointly, my client should have the opportunity to claim the children if she does work during this year.
We have very brief response, Your Honor. Not only is my client, he's already based his tax, withholdings 5 months, almost 6 months into the year now, counting on claiming the children as he had traditionally done. But most importantly, she'd have to claim, my client quickly did some research, and looks like the standard deduction for 2023 is $13,850 with the $2,000 child tax credit. She'd have to earn somewhere around $18,000 before that even benefited her tax wise. And it's not even that she says she's applied for jobs, made applications, or has a job coming up, or minimum wage job coming up, or it's all what ifs, if this may occur. She argued just the opposite in our temporary orders hearings, that she didn't have a reasonable likelihood in the near future to obtain employment. So, it seems to be opposite of what the court based its ruling on.
And Your Honor, if I could just note, this is standard language. Usually the parties do split these exemptions. So that's the only reason we put that in this way and ask for that credit.
I don't disagree. It's standard language, certainly, Your Honor, but that's for people that have jobs and income and whatnot. Here, it was argued that that wouldn't be the case, and it's still not the case. So I think for 2023, and again, we're just trying to limit it to that.
Okay, so I've changed two different things here. So on page 4 under 19, I wrote 2024 and beyond for that first section, and then added at the end of that sentence, unless changed in a subsequent court order. And then on page 5, I changed the example. So for tax year 2024, must pay all 2024 support by January 31st, 2025 to claim on 2024, just to kind of work with how I'm wording this here. And then after the last line before section 20, I said for 2023, John Ellis will claim all children for tax purposes unless Heidi Ellis makes over $13,000 in 2023. If she does, it will revert back to the above plan. So if Miss Ellis is gainfully employed and is able to make at least $13,000 in 2023, then we stay with the split as above. If not, Mr. Ellis will, for 2023, be able to claim all the children, assuming he's up on all of the support. All right. And then I believe there was no issues with the temporary family law order. Is that correct? Yes.
No, Your Honor, sorry.
All right. And then parenting plan.
Yes, Your Honor, and then you saw that too. We objected to one section of the parenting plan, specifically paragraph 12 regarding transportation of the children. As Your Honor, I'm sure recalls, this was a situation where there was, 5 or 6 months of unsupervised visitation going on before the matter came before the court. The court had to consider whether they wanted to grant mother's request for supervised visits or not. The court ultimately ordered supervised visits to occur. I asked about transportation, primarily for the reason that my client didn't have a car big enough to transport all the children. They have 5 children. We talked about maybe using mom's car if necessary. The court responded, and according to the clerk's notes, that the more mom can do, the better. The children can ride in 2 cars if necessary. The clerk's notes also say court orders all children visitation and third party to help with transportation. So it's our understanding that father was going to transport the children to wherever they were going for this visit with a supervisor. There's no question that it was to be unsupervised. The dispute seems to be now that mother is asking for certain children to ride with father, other children not to ride with father, or frankly, if the supervisor has a big enough car, no children ride with father is how I read that. We don't believe that was the court's intention at all. The court was very lucid regarding the transportation provisions and getting to where they're doing the supervised visits with. They have multiple supervisors. It's not a professional situation in different people's homes and throughout the community and family members. We're asking the court to what we believe was its intention to allow him to transport as many children as possible, and the third party and or supervisor could help with the transportation if necessary. If mother would help, that'd be fine, but otherwise it was ordered that she would do the picking up transportation or on the back side of the visitation, excuse me. So that's my client's primary dispute. They want to limit his ability to even transport his children and whatnot, and which children he can transport. We don't believe that was the court's intention.
So I am reviewing your ruling on this matter. And when we discussed the issues regarding the driving, you did say that there was going to be a third-party supervisor. And specifically, it says that at through a wrench and things, I'm not changing the decision. I think the third party should transport the kids out or all the children at this point. So you stated specifically that the transportation was supposed to be provided by the supervisor. The issue is if there weren't sufficient seats, then father could transport any additional children. At this point, there's been conflict with the eldest children. We brought it up in court, but you didn't have enough information to make a decision at this point, or at that point. Without getting into the weeds with additional information, since the visitations have occurred, there's still been ongoing conflict with
Your Honor,
the
this is
eldest.
not before the court.
So
It's strictly disputed.
So I believe that my client is here if the court wants additional testimony, because you did state if for some reason we get into a situation where Mr. Ellis and the third party show up and the 14-year-old is unwilling, we can address that hurdle. So since we're entering orders, it's appropriate to bring this to the court's attention. First of all, that the supervisors are the ones that should be transporting the children. And secondly, only if there's additional need for seats that the children would be in father unsupervised. So I would like to bring more information to the court's attention, but I understand it's not in the record.
So hold on, Mr. Davis, there's two things. So I have to apologize because the parenting plan that I reviewed didn't have any of this language. So I was a little concerned or confused, excuse me, by the objection, because the one I have says supervised visitation provider shall provide transportation to allow all children to attend visits, and father may travel with children without supervision to attend visitation, and mother may provide transportation as agreed for the children. And then I the one I received today says if there are not sufficient seats in the supervisor's car, only the youngest children will that will not fit in supervised vehicle shall ride with father for transportation purposes. So now I understand, I guess, Mr. Davis's objection, because I didn't see where it was dictating who could ride where.
So for clarity, I did submit new orders on May 11th, and I expected you would receive those because we mailed them out on Wednesday a week ago. So those are the new orders and where the basis of Mr. Davis's objections lie, because we did make a number of agreements and changes. So I
received the May 11th orders today. So
okay,
just so you're aware. And I was provided the May 8th orders from the clerks yesterday. And then today I got the May 11th order. So I understand the concern. My assumption would be that older kids are probably going to hop in the supervisor's car if they're not wanting to be around dad, or if that's an issue. I'm striking only and youngest from that last sentence. So basically it will read, if there are not sufficient seats in the supervisor's car for all children, the children that will not fit in supervisor's vehicle shall ride with father for transportation.
Can the children choose who to ride with then? How are we, I guess.
Yeah, I'm not going to dictate that. If they jump into the supervisor's vehicle first and take a seat there, then I don't think, I guess I don't want, and I'd ask you to just let your client know this, Mr. Davis. I don't want your client to then start rearranging where everybody is. Let it just kind of happen. I understand that this is a weird transition, and then some of the older kids are struggling. That's expected. It's expected. And there could be other layers of issues beyond just parents separating. And I acknowledge that, but I'm not going to, I don't have enough information to go too far down that road. So hopefully it can just kind of be an organic thing, and the older kids beat the younger kids to the seats in the other car. Okay. Were there any other issues, Mr. Davis, in the parenting plan?
One other issue, same paragraph.
Okay.
Well, I guess I don't know. You don't have the latest one, it sounds like, or maybe you do now.
No, I do now. Yes.
It says, second paragraph on that one says there should be no verbal communication between the parents at the exchanges. While I agree that there can be distance and whatnot, there still needs to be communication when there's 5 children transferring. 2 of them are pretty young, I believe, 2 and 4, if I recall correctly. My concern with that is, while we both encourage our clients to limit, children specific only necessary things, it's just setting him up for a contempt, violation of the parenting plan situation, when all the kids are coming out and whatnot. So that's our big concern. I understand you normally prefer parenting plan app. I forget the name, Family Wizard, which is fine for most issues, but at the exchanges, sometimes those issues we need to communicate.
And Your Honor, just to remind you, this was a request originally from my client for a restraining order. The court denied the restraining order and did issue an order stating that father shouldn't come to the residence other than as agreed or for the visitation purposes. There is a level of conflict. My client did describe some pretty serious domestic violence issues. We're trying to do everything to avoid any kind of confrontation, conflict, or issues at these exchanges. We've put in there specifically one parent remains with the vehicle. The children can come to the vehicle. There are 2 younger children. The older children can bring them to the vehicle. There's no need for any contact or conflict between the parties at the exchanges, and that's what we're trying to avoid.
So I understand, Mr. Davis, the concern, but there's a supervisor there. So if there's, one of the kids is having some difficulties, that can be relayed to the supervisor, who can relay it to the other parent. I'm going to leave that language as it is in the order. And then if we get to a point where we're not on supervised visitation, I'm happy to readdress that.
And so for the record, I do want to make sure that you've entered the temporary family law order that was signed on 5/11 as well, because it reiterated changes that match the child support order. So I do want to clarify to make sure we're not entering separate orders that are not all from the 11th.
I took my notes off the old ones off the May 8th and then chucked them in the recycle pile. So I did sign the May 11th family law order, temporary family law order.
Thank you very much.
All right.
The only other thought that comes to mind is obviously we're here for another hearing. Objections were never filed timely. My client would ask for fees for having to attend a second hearing, just merely because a lot of these things could have been agreed to or resolved prior to our last hearing, and we wouldn't have to be here again.
I don't, Your Honor, we provided those objections to counsel the day, at least one day in advance to her in writing. The court asked us to recite this and try and confer with each other to see if we could resolve some of the issues, which you did resolve a fair number of the issues, and tried to bring this back to the court where it's just the remaining issues you decided today. There's no basis for fees in our understanding, Your Honor, as it was that the orders that were posed changed multiple times, as you pointed out. And so there's no basis for fees. The court asked us to do this. This is why we're here. We accomplished what the court intended. I don't see that there's any bad faith basis whatsoever, especially when the orders are changing. The first proposed orders, as you identified, provided something else.
I'm not going to impose any attorney's fees for this. I asked for those to be in writing, given the length of our docket last week. So I'm not going to impose any fees at this point. So I'll deny that request. All right.
I believe that's all that was before the court, if Ms. Green can correct me otherwise.
Yes.
Nope, it looks like just to enter those orders. So, all right. Good luck to the family. Thank you.